A K-1 visa is a fiancé visa that enables an applicant from outside of the United States who wants to join a fiancé in the United States to file a petition with USCIS asking to be given a 90-day visa to come to the US to see if this relationship is going to lead to a marriage. A K-1 involves filing an I-129F form with USCIS. The adjudication time period is roughly about 8 months as of right now. And once that application is granted, showing that, you have seen that person who you wish to marry within the last 2 years, and you have an intent to marry within 90 days of entry, along with affidavits from friends and family and other proof of your relationship, such as travel history, passport, stamps, tickets to the country where you've met, might be a third country, for example. All those things are filed together, and USCIS will process that petition, and once approved, will send it directly to the consulate. So in some respects, if you're considering a marriage-based versus K-1-based process for your significant other, by filing a K-1, you skip the middleman, which is the National Visa Center, which is quite nice. What ends up happening is that the file gets sent to the consulate, and the consulate will enable you to file a non-immigrant visa application, the DS-160, online. And at that point, an interview will be scheduled, and if the interview goes well, then the individual is able to enter the United States with a K-1 visa. And within 90 days, as long as you get married within the 90 days, you can file the I-485 application for adjustment of status without having to file an I-130, since you ended up coming to the U.S. on an approved I-129F. And then when the application is approved, sometimes that means you don't have an interview because they've already determined that the relationship is genuine at the I-129F interview at the consulate. So a K-1 can be a nice way to get your significant other here a little bit more quickly, not dramatically more quickly, but more quickly, and with less financial proof obligations, since you'd be filing an I-134 affidavit of support, not an I-864, which would survive a divorce.